Hi, my name is Anna Castro and I work for the American Civil Liberties Union, the ACLU. You may have recently heard about a case we settled with the government called Lopez-Venegas v. Johnson. Or maybe you've heard of the possibility that hundreds, maybe thousands of non-citizens who were expelled from Southern California to Mexico may be able to return to the United States if they meet certain requirements. Before I go over who qualifies for help under this settlement, let me tell you about the work the ACLU does and why we filed this lawsuit. The ACLU is a nonprofit organization that works in the courts, in the legislature, and in communities in the United States to defend and protect everyone's rights. These rights are granted to us by our laws and through the Constitution. The ACLU does not charge for its services. Since 1933, the ACLU of San Diego and Imperial Counties has fought for the basic human rights and dignity of immigrants and all people living in the region of the U.S.-Mexico border.
Mi nombre es Isidora López-Venegas y la ACLU me representó cuando la patrulla fronteriza violó mis derechos constitucionales. Llegué a los Estados Unidos en el 2001 con una visa válida. Me establecí en San Diego donde crié a mis hijos, incluyendo a mi hijo de 13 años, que es ciudadano americano. Hace 3 años los agentes de la patrulla fronteriza me pararon y se acercaron a mí y a mi hijo para exigirme los papeles. Ellos nos llevaron a la estación de la patrulla fronteriza y me dieron una forma con respuestas preseleccionadas que repetidamente y forzadamente me pedían firmar. Me dijeron los agentes que si no firmaba mi salida voluntaria, me encarcelarían por varios meses y que me quitarían a mi hijo para llevarlo a un foster home o un hogar temporal. Me dijeron que debería tomar la opción de salida voluntaria porque fácilmente podría arreglar mis papeles desde México, porque mi hijo es ciudadano americano. Me dio mucho miedo ser separada de él y creí a los agentes, entonces firmé la salida voluntaria y en pocas horas fui expulsada a México. Luego aprendí que no podía arreglar mis papeles desde México y que al firmar la salida voluntaria había perdido mi oportunidad de representar mi caso ante un juez de migración.
First, let's talk about the basics. What is voluntary return? Voluntary return is an informal process in which an individual who has been detained by Border Patrol or Immigration and Customs Enforcement agrees to be immediately expelled from the United States instead of going through formal removal proceedings in front of an immigration judge. When the ACLU began investigating voluntary return, we discovered that for years, countless families throughout Southern California had been torn apart by immigration enforcement agencies' coercive and deceptive voluntary return practices. The people that we are talking about were people who had deep roots in the United States and who had no significant criminal history. They were the kind of people who are very low priority for enforcement. We learned that too often ICE and Border Patrol have misinformed immigrants about the consequences of voluntary return, including telling people that they could fix their papers from Mexico without telling them that voluntary return can trigger a 10-year bar against returning to the United States. In many cases, immigration officers used pressure and threats to convince people to sign voluntary return forms. Faced with such pressure, threats, and misinformation, many immigrants signed away their right to see a judge without understanding the consequences and have been separated from their families and lives in the United States. In June 2013, the ACLU and several partners filed a lawsuit in Southern California challenging the abusive practices government agents used in administration of voluntary return. Today, we are pleased to let you know that the ACLU reached a historic settlement with the government to set in place significant reforms to end deceitful immigration practices. The bottom line is that unfair voluntary return should never happen again in Southern California. What does that mean? 2 things. First, the government has agreed to make significant changes to the way voluntary return is administered in Southern California. And second, for some people who were expelled from Southern California because of the flawed voluntary return procedures over the last few years, the court said if they meet certain specific requirements, they could return to the United States to argue their case before an immigration judge. We need to emphasize something that is very important. Many people have been expelled to Mexico, but only some were expelled by the voluntary return process. Many people can benefit from this settlement, but many more will not qualify. This information will help determine if you can benefit from the settlement and what to do next if you are a potential class member. If you can answer yes to all the following questions, you may be able to benefit from this settlement. Were you expelled to Mexico from Southern California? Did you accept a voluntary return? Did you accept a voluntary return between June 1st, 2009 and August 28th, 2014? Were you processed by Border Patrol or ICE of San Diego, Imperial, Orange, Riverside, Los Angeles, San Bernardino, Ventura, Santa Barbara, or San Luis Obispo County? What's next? If you answered yes to the questions above and think you may qualify as a class member under the voluntary return settlement, please contact the ACLU at avd@aclusandiego.org, or from the US call 619-398-4189, or from Mexico dial 0-1-800-681-6917. Remember, only the ACLU and ACLU-approved organizations will be authorized to submit class membership applications. The initial screening, consultation, and application will be free. The ACLU will return all calls and emails and conduct an initial screening. We're receiving a large number of calls and emails. Please be patient. It may be a few weeks before we contact you. After we contact you, if we determine you're a class member, the ACLU may submit an application for class membership on your behalf. It's very important to understand that qualifying as a class member is not the same as receiving lawful immigration status. By qualifying as a class member, you will not receive a green card. Qualifying as a class member doesn't mean you'll receive a work permit. The benefit you receive from being a class member is the opportunity to return to the United States and fight your case in front of an immigration judge. As part of the settlement, the named plaintiffs were able to return to the United States and to their families. This relief is available to other people whose rights were similarly violated. Now we can begin the process of reuniting some of the families that were driven apart by government practices that relied upon misinformation, deception, and coercion. If you think you qualify for relief under the settlement, don't wait. Call us or email us now.